Welcome to Virtual History Tours, your guide to people, places, and events that have shaped the world we live in. You've accessed Understanding the Constitution, the Judicial Branch. Your tour will begin in 3, 2, 1.
Welcome! I'm Allison, your tour guide, and I'm going to take you on a video tour of the judicial branch of our federal government. That's the branch that interprets the country's laws. At the head of the judicial branch is the Supreme Court of the United States. So let's start our tour at the home of the Supreme Court in Washington, D.C. This is the Supreme Court. Inside this building, decisions are made that affect the lives of every one of us. It just might be that you go to the school that you do because of a Supreme Court decision. That's right. In 1954, the Supreme Court said that schools couldn't separate children by their race. Before that decision, in certain states, there were laws that said that white children had to go to one school and African American children had to go to another school. It's hard to even imagine that now, but before the Supreme Court said that those kinds of laws went against the Constitution, that's the way things were. That decision was called Brown versus the Board of Education. That's how all court cases are referred to. One side versus or against the other. We'll talk more about Brown versus the Board of Education a little later. Before we do that, let's talk about how the Supreme Court, the judicial branch, and the whole federal government came to be. For that, we have to travel back in time to 1787, and that's what we're going to do now. This is Independence Hall in Philadelphia. It's called that because this is where, in 1776, the leaders of the 13 colonies declared their independence from Great Britain and King George III. It is also the place where the leaders of the 13 states came in 1787 to write a constitution for the new country. What's a constitution? A constitution is a framework or an outline for a government. The people who came here in 1787 didn't actually plan to write a new constitution. They only wanted to revise the one that was already in place. It was called the Articles of Confederation. A confederation is a very loose association of strong, independent parts. Under the Articles of Confederation, the states, the parts, had most of the power. The central government had very little. But that government wasn't working very well. Why? Well, let's hear what two important leaders of the time have to say. First, James Madison of Virginia.
This government cannot succeed because the Articles of Confederation lack the great principles of a political system. It's merely a treaty of friendship between the various states.
Now let's see what Alexander Hamilton of New York has to say.
The fundamental deficiency with this government is that Congress has no power. Congress must have powers to deal with national problems. And there is no central court system, so when various states have a dispute, there is no place for them to go to work out their differences. The third deficiency, and it is a great one, is that there is no central leader, no chief executive the people can point to as the head of government.
So, a convention was called to meet in Philadelphia in May of 1787 to revise the Articles and make them stronger. Remember, Alexander Hamilton said that the reason the Articles were so weak was that there was no Congress with any power, no national court system, and no central leader? Well, a plan was presented to the convention to deal with those issues. Governor Edmund Randolph of Virginia made the presentation, but it was really the work of James Madison. It was called the Virginia Plan.
The Virginia Plan called for the government to be divided into 3 departments or branches. The legislative branch, which would enact the laws, the executive branch, which would see that the laws were carried out, and the judicial branch, which would see that justice was done under the law.
Madison's idea took hold. After some debate, a resolution was passed.
A national government ought to be established consisting of a supreme legislative, executive, and judiciary.
The delegates had taken a bold step. Now, instead of just revising the articles, they would create a new constitution. Many people contributed to the writing of the Constitution, but no one was more important than James Madison. His contribution was so great that he is known as the father of the Constitution. Why did Madison think it was so important to divide or separate the powers of government into 3 branches?
The separation of powers was very important. We had to guard against the accumulation of all powers, legislative, executive, and judicial, in the hands of one person, or a few people, or even a group. It doesn't matter if the powerful are elected, self-appointed, or born to their office. If the powers aren't separated, the result is tyranny.
Once they decided to write a new constitution, the delegates went to work on specific issues. It was generally agreed that there had to be national courts. Otherwise, as Alexander Hamilton had said, there would be no way to settle disputes between the states. But there was some disagreement about who would appoint the judges, the executive branch or the legislative branch. James Madison, who took careful notes at the convention, describes the situation.
Most all of the delegates saw the need for national courts. And even though some objected, we were able to reach agreement that the national legislature, the Congress, would establish the courts. Most were also in agreement that the judges should be appointed for life. That way, they would not be subject to influence for fear that they would lose their appointments. As a safeguard, though, we did set up procedures for removing judges from the courts who did not exhibit good behavior. The real problems at the convention arose over the question of who would appoint the judges. I supported appointment by either the President or the Senate. Others objected to that. They preferred to have the House of Representatives make the appointment. In the end, we found a solution in compromise. And that was the way it was with most every issue we debated at the convention. No matter how heated the debate, we were able to compromise. And the willingness to compromise, I am sure, was the secret of our success. On the particular issue of the appointment of federal judges, the compromise that we arrived at was to have the executive appoint the judges and then have the Senate approve the appointment.
Giving the executive and the legislature a say over the judiciary is an example of a system built into the Constitution called checks and balances. Checks and balances means that each branch of the government has some say over what the other branches do. That way, no one branch of the government can get too powerful and none can function without the cooperation of the others. It's an assurance that power is kept in balance. So in this case, the president has a check on the judiciary because he nominates the judges, and the Congress has a check on both by having the authority to approve or reject the nominations. The judicial branch also has a very powerful check. It can declare congressional and presidential acts unconstitutional. That means it can say that the law violates the Constitution and cannot be put into effect. The court system is an example of an important principle built into the Constitution called shared powers. That means that the national or federal government shares powers with the states. The federal government has specific powers, and the states have specific powers, and then there are powers that they share. For example, the federal government declares war and prints money. The states establish their own schools, and local governments. But both the federal government and the state governments impose taxes and regulate banks, and they both have court systems. At the time the Constitution was written, it was generally thought the judiciary would be the weakest of the three branches of government, but it didn't turn out that way. The case that firmly established the power of the court involved James Madison. It was called Marbury versus Madison.
I became involved in this case in my position as Secretary of State in the administration of President Thomas Jefferson. This was the situation. In 1800, Thomas Jefferson, a member of the Democratic-Republican Party, was elected president. The outgoing president was John Adams, a Federalist. The Federalists had not only lost the presidency in the election, they lost the majority in Congress as well. So they decided to find a way to keep control of the courts. Between the time Jefferson and the new Congress were elected and the time they took office, the Federalist Congress passed the Judiciary Act of 1801. This act increased the number of judges so that President Adams could appoint as many Federalists as he could. Now, you must keep in mind that travel and communication for us was very slow and difficult. So not all the notifications of appointments were made before President Adams left office. One of the appointments that was made but not delivered until President Jefferson was sworn in was one William Marbury, who had been appointed a Justice of the Peace for the District of Columbia, a very minor position. As I was Secretary of State, Marbury expected me to install him in his post. I refused. Marbury sued. The case went to the Supreme Court. The Chief Justice at the time was John Marshall. Chief Justice Marshall made a most astonishing pronouncement about the case. He said that the law under which Marbury's appointment had been made was unconstitutional. Congress, he said, had gone beyond the powers it was given by the Constitution in making such an appointment. In writing his opinion, the Chief Justice said, "It is emphatically the province and duty of the Judicial Department to say what the law is." In one grand moment, Chief Justice Marshall made the Supreme Court the equal of the President and Congress.
The principle of declaring a law to be unconstitutional is called judicial review. It means that the Supreme Court has the final say in deciding what the law of the land is. The Supreme Court is the only court mentioned in the Constitution.
The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish.
But the Constitution doesn't say how the court should be made up, and it doesn't say what other federal courts there should be. That is all left up to Congress. Setting up the courts was one of the very first things Congress did at its first session in 1789. The Federal Judiciary Act said that the Supreme Court would be made up of one Chief Justice and 5 Associate Justices. John Jay of New York was appointed the first Chief Justice. As the country grew, more Associate Justices were added to the court. Since the middle of the 19th century and still today, the court is made up of one Chief Justice and 8 Associate Justices, 9 members in all. The Supreme Court is the highest court in the land for both federal courts and state courts. It has the power to decide if laws are constitutional, and it also has the right to say what laws mean. Every year, thousands and thousands of cases come here to be heard and reviewed. But only the most important cases, those that will have an effect on the country, get the court's attention. One such case was Brown versus the Board of Education. Brown versus the Board of Education ended segregation in American public schools. Segregation means that white people and black people are separated. Even though the Civil War ended slavery, in many parts of the South, segregation laws were passed to keep whites and blacks apart. So, there were separate schools, separate buses and trains, even separate water fountains and bathrooms. Many people objected to these laws and said they went against the Constitution. In 1896, a case reached the Supreme Court that challenged a segregation law in Louisiana. The case was Plessy versus Ferguson. Homer Plessy, an African American, had been arrested when he refused to move from a railway car designated for whites only. He said his rights had been violated. But the Supreme Court ruled that his rights had not been violated. The justices said that as long as railway cars were equally provided for blacks, separating the races was not unconstitutional. The doctrine was called separate but equal. A Supreme Court ruling, as Chief Justice John Marshall had said, is the law of the land. But that doesn't mean that people can't try to get that ruling changed. So a battle was waged to overturn Plessy versus Ferguson. Leading the battle, the National Association for the Advancement of Colored People, the country's oldest civil rights organization. The NAACP and their chief attorney, Thurgood Marshall, concentrated their efforts on changing the doctrine of separate but equal in schools. The truth was that segregated schools were never equal. White children had better books and equipment and better school buildings than black children did. When the case came to the Supreme Court, Thurgood Marshall argued that separate schools could never be equal. This time, the court agreed. In May 1954, Chief Justice Earl Warren delivered the court's historic opinion. "We conclude," the Chief Justice said, "that in the field of public education, the doctrine of separate but equal has no place." Brown versus the Board of Education was the beginning of the end of segregation in America. The Supreme Court had changed the course of American life. By the way, Thurgood Marshall went on to become the first African American on the Supreme Court. He was appointed in 1967. In 1981, Sandra Day O'Connor became the first woman on the court. There have been many changes to the Constitution since it was written in 1787. Amendments have been added to guarantee our personal liberties and to correct problems that the framers did not anticipate. One of the greatest changes has been the growth in the role and power of the judicial branch. Today, the court can truly be called the Supreme Court of the United States of America, a full partner in our national government. That concludes our virtual tour of the judicial branch of the Constitution. Hope you enjoyed it. See you next time.